You need to leave now. What? I'm just having coffee. The manager says you're making people uncomfortable. You're trespassing. I bought this coffee 10 minutes ago. I'm not bothering anyone. Are you leaving or do I need to remove you? You're making a mistake. I'm FBI Special Agent Jennifer Monroe. I don't care if you're the president. You're leaving. Show me some aid. Here, FBI credentials. Special Agent Jennifer Monroe. Nah, do you understand this is a mistake? Anyone can print a fake badge. Stand up and put your hands behind your back. Officer, that is a legitimate federal credential. You can verify it with one phone call to the Seattle FBI field office. I'm asking you to do that before this goes any further. Stand up now. Officer Marcus Webb had been with the DeKalb County Police Department for 11 years. When he made a traffic stop that would destroy his career and cost the county $4.7 million. He was 38 years old, experienced enough to understand constitutional rights and departmental policy, but apparently convinced that his authority trumped the law itself. One Thursday morning on Interstate 285 outside Atlanta, he pulled over a black woman in a late model sedan driving to work and manufactured a violation that didn't exist. The black woman was Judge Evelyn Carter, a 19-year veteran of the federal bench with a national reputation for meticulous legal reasoning and zero tolerance for civil rights violations. What Webb did next, ignoring her judicial credentials, forcing her from the vehicle without cause, and detaining her on the side of a busy interstate, would become a federal case study in how racial profiling by law enforcement creates constitutional violations. His body cam recorded everything. His dash cam captured it all. And his department's failure to address 14 prior complaints would transform one illegal traffic stop into a systemic accountability reckoning that would change departmental policy forever. A black woman in her late 50s, Judge Evelyn Carter, was driving eastbound on Interstate 285 in her silver Lexus sedan on her way to the federal courthouse in downtown Atlanta. Her judicial robes were hanging in the back seat. Her briefcase sat on the passenger seat containing case files for a 9 o'clock hearing. No traffic violation, no erratic driving, no reasonable suspicion, just a federal judge commuting to work. But Officer Webb saw her through a lens so distorted by racial bias that he couldn't imagine a black woman in an expensive car belonged behind the wheel. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. Interstate 285 encircles Atlanta like a concrete collar. 285 miles of perpetual traffic, aggressive lane changes, and commuters racing to beat rush hour. The eastern stretch through DeKalb County cuts through neighborhoods that transition from working class to affluent within a few exits. Expensive homes sit minutes from apartment complexes. BMWs share lanes with 20-year-old sedans held together by determination and duct tape. It was 7:42 in the morning on a Thursday in late September. The morning sun was still low, casting long shadows across 6 lanes of eastbound traffic. Rush hour was building but hadn't peaked yet. Cars moved steadily at 65 miles per hour. The air was thick with Atlanta humidity, the kind that clings to your skin the moment you step outside. This stretch of Interstate 285 runs through an area where DeKalb County police patrol aggressively. They're known for traffic stops that seem selective. Expensive cars driven by black drivers get pulled over at rates that community advocates have challenged for years. The statistics are public record. The complaints are documented, but the stops continue. Judge Evelyn Carter had driven this route 5 days a week for 19 years. She knew every exit, every merge lane, every spot where officers like to park and run radar. She drove carefully, always 5 miles under the speed limit, always signaling lane changes well in advance, always aware that her skin color made her a target even in her own car. That Thursday morning, she was in the right lane, heading toward the Candler Road exit, her usual route to the courthouse. She had merged smoothly from Interstate 20, used her signal, checked her mirrors. She was driving exactly as the law required. And Officer Marcus Webb, sitting in his patrol car on the shoulder near the exit, saw her and decided she didn't belong in that car. Judge Evelyn Carter had been on the federal bench for 19 years. 19 years presiding over complex civil rights cases, criminal trials, and constitutional challenges that shaped legal precedent across the 11th Circuit. She had been appointed to the United States District Court for the Northern District of Georgia at 39 years old, one of the youngest federal judges in the country at the time, and one of fewer than 50 black women to serve on the federal bench nationwide. Her docket was demanding. Class action employment discrimination suits, voting rights cases, federal criminal prosecutions, habeas corpus petitions. She had presided over trials involving corporate fraud, police misconduct, and constitutional violations. Her rulings were cited in appellate decisions. Her legal reasoning was studied in law schools. Her reputation was unimpeachable. Meticulous, fair, and unwilling to tolerate government overreach or civil rights violations from any party. Federal judges don't campaign for their positions. They're nominated by the president and confirmed by the Senate. Carter's nomination had been unanimous. Both parties respected her legal mind, her temperament, and her commitment to the Constitution. Carter had graduated from Spelman College summa cum laude with a degree in political science, then Yale Law School, where she had been an editor of the Yale Law Journal, and graduated in the top 5% of her class. She had clerked for a judge on the 11th Circuit Court of Appeals, then worked as an assistant United States attorney for 6 years, prosecuting federal crimes and earning a reputation as a brilliant trial lawyer who never lost a case she personally tried. She had served as a state court judge in Fulton County for 8 years before her federal appointment, handling criminal and civil matters with a docket that moved faster than any other judge in the courthouse. Lawyers respected her. Prosecutors and defense attorneys both knew she was fair, prepared, and impossible to fool. She had received the American Bar Association's Distinguished Jurist Award. She had been named one of the most influential women in Georgia law. She had lectured at law schools across the country on civil rights jurisprudence and constitutional law. At 58 years old, Evelyn Carter was exactly where she had worked 3 decades to be. Respected, influential, and trusted with cases that required both legal brilliance and moral clarity. She had sacrificed personal time, weekends, holidays, the cost of a judicial career. She had never married, dedicating herself entirely to the law. She lived in a modest home in East Atlanta, drove a car she had owned for 8 years, and spent her rare free time mentoring young black women lawyers who aspired to the bench. She wasn't flashy. She wasn't seeking attention. She was a judge who had built a career on fairness, precision, and an unwavering commitment to constitutional rights. That Thursday morning, Carter was driving to the federal courthouse for a 9 o'clock hearing in a civil rights case, a lawsuit brought by a family whose son had been killed by police during a traffic stop. She had reviewed the evidence. She had read the depositions. She was prepared to rule on a motion to dismiss. The case was exactly the kind she had presided over dozens of times. A family seeking accountability, a police department arguing qualified immunity, and a judge tasked with determining whether constitutional rights had been violated. She had left home at 7:30, her usual departure time, dressed in a navy blazer and skirt with her judicial robes hanging in the back seat. Her briefcase contained case files, legal briefs, and a draft opinion she had been working on. She had stopped for coffee at a drive-through Starbucks, then merged onto Interstate 20 toward Interstate 285. She wore minimal jewelry, a watch, small earrings, and no visible indicators of her profession. She looked like what she was, a professional woman commuting to work. She had committed no traffic violation. She had done nothing to attract attention. But to Officer Marcus Webb, watching traffic from the shoulder of Interstate 285, Judge Evelyn Carter's presence behind the wheel of a Lexus sedan was suspicious, and he had decided to do something about it. Marcus Webb was 38 years old. He had been with the DeKalb County Police Department for 11 years, working patrol on Interstate 285 and surrounding highways where traffic stops were frequent and scrutiny was minimal. He was confident, assertive, and convinced that his instincts about suspicious drivers were reliable. His supervisors described him as proactive and results-oriented. Department code for makes lots of stops and writes lots of tickets, but occasionally crosses lines. Webb had ambitions. He wanted to move into specialized units, narcotics, gang enforcement, something with more prestige than highway patrol. But those promotions required a track record of good stops, solid arrests, and clean complaints. And that's where Webb's record became problematic. In 11 years, Webb had compiled a disciplinary record that should have disqualified him from patrol duties. 14 complaints. 14. 10 of them involved allegations of racial profiling, unlawful stops, or excessive force against black drivers. 4 had been sustained, resulting in written reprimands, mandatory retraining, and suspensions totaling 6 weeks without pay. The other 10 had been closed as not sustained or unfounded, despite witness statements, dashcam footage, and documented inconsistencies in Webb's reports. Webb had a pattern. He pulled over black drivers in expensive cars, manufactured violations that didn't exist, and escalated encounters unnecessarily. A black businessman driving a Mercedes on Interstate 285. Webb claimed the driver was speeding at 82 miles per hour. The driver's dashcam, showed he was driving 67 miles per hour. The complaint was sustained. Webb received a written reprimand. A black woman driving a BMW with her teenage daughter. Webb claimed she had failed to signal a lane change. For witnesses and dashcam footage showed she had signaled properly. Webb searched her car anyway, finding nothing. The complaint was sustained. Webb was suspended for 2 weeks. A black man driving a Range Rover. Webb claimed the vehicle matched the description of a car involved in a robbery. No robbery had been reported. The stop lasted 40 minutes while Webb searched the vehicle and ran the driver's name through multiple databases. The complaint was closed as unfounded because Webb claimed he had received information over the radio. The radio logs showed no such transmission. The pattern was documented. The evidence was extensive. But somehow Webb remained on patrol. His union protected him. His supervisors noted problems in evaluations, but took no meaningful action. The system was designed to protect officers, not drivers. That Thursday morning at 7:41, Webb was parked on the shoulder near the Candler Road exit, watching eastbound traffic. He had already made 2 stops that morning, both warnings, both black drivers, both in cars Webb considered too nice for the neighborhood. He saw Judge Carter's silver Lexus in the right lane, traveling steadily at 62 miles per hour. The car was clean, well-maintained, expensive. The driver was a black woman, alone, dressed professionally. In Webb's mind, something didn't add up. Black woman, expensive car, early morning. She didn't fit his expectations for this route. He pulled onto the highway behind her, paced her for half a mile, and watched for any violation he could use as justification. She didn't speed. She didn't change lanes. She didn't touch her phone. She drove perfectly. So Webb manufactured a violation. At 7:42, Webb activated his lights and siren. Judge Carter saw them immediately, checked her mirrors, signaled right, and pulled onto the shoulder safely. She put the car in park, turned off the engine, and placed her hands on the steering wheel at 10 and 2, exactly as she had done dozens of times before, because she knew that traffic stops for black drivers carried risks that white drivers never considered. Webb approached the driver's side window, his hand resting on his service weapon. His body cam was recording. His dash cam was recording. Everything that happened next would be documented. He looked through the window and saw exactly what he had expected, a black woman in an expensive car. In his mind, that confirmed his suspicion. She didn't belong here. Do you think officers should face automatic termination after 5 sustained complaints for racial profiling? Drop your answer below. Judge Carter lowered her window as Officer Webb approached. She kept her hands visible on the steering wheel, her movements slow and deliberate. She had presided over enough police misconduct cases to know exactly how these encounters could escalate. License and registration. Now, Carter's voice was calm, professional, measured. Of course, officer. May I ask why you pulled me over? Webb's jaw tightened. He wasn't used to drivers asking questions. Don't ask questions. Just hand them over. Carter reached slowly for her purse in the passenger seat, narrating her movements. I'm reaching for my purse now. My license is inside. She pulled out her wallet, removed her driver's license, and handed it through the window along with her registration from the glove compartment. Webb glanced at the license. Evelyn Carter, Atlanta address. Clean driving record visible on the license itself. No restrictions, no violations noted. He looked at the registration. The car was registered to her. Everything was in order. But Webb had already committed to this stop. He couldn't back down now. I wasn't speeding, Carter said. Her tone remained professional but firm. I used my turn signal. My tags are current. What's the reason for this stop? You were driving erratically, swerving between lanes. Carter's expression didn't change, but her voice sharpened slightly. I wasn't swerving. I've been in the right lane for the past 3 miles. I haven't changed lanes since I merged from Interstate 20. Webb's hand moved closer to his weapon. I know what I saw. Carter had presided over enough cases involving unlawful stops to recognize what was happening. This wasn't about traffic violations. This was about a black woman in a car that Webb didn't think she belonged in. Officer, I need to inform you that I'm a federal judge. I'm Judge Evelyn Carter, United States District Court for the Northern District of Georgia. I'm happy to provide my judicial credentials, which are in my briefcase. This stop appears to lack reasonable suspicion, and I'm asking you to articulate a specific violation. Webb's expression hardened. Sure you are, and I'm the president. Step out of the vehicle. Carter kept her hands on the wheel. Officer, I'm serious. I'm a sitting federal judge. My credentials are in my briefcase on the passenger seat. I can show them to you, but I need to know the legal basis for this stop. This is where bias becomes impenetrable. Officer Webb had pulled over a black woman in an expensive car, when she asked questions instead of complying silently, when she spoke with authority instead of deference, when she identified herself as a federal judge instead of accepting his narrative. Webb's mind couldn't process it. Every piece of evidence, the calm demeanor, the professional clothing, the articulate speech, was filtered through his initial assumption. He wasn't looking at a federal judge. He was looking at someone challenging his authority, someone who needed to be reminded of their place. Traffic continued to rush past at 65 miles per hour, cars swerving slightly to avoid the stopped patrol car. Some drivers glanced over. A few slowed down slightly watching. One driver, a white man in a pickup truck, pulled onto the shoulder 50 yards ahead, his phone already out, recording. Out of the car. Nah, or I'll remove you myself. Carter took a slow breath. She had spent 19 years on the bench. She had presided over trials involving police officers who had made exactly these kinds of mistakes. She knew how this would end if she resisted. She also knew her rights. Officer, I'm complying under protest. This is an unlawful detention. You have not articulated reasonable suspicion for this stop. You're detaining a federal judge without cause, and you're making a career-ending mistake. Webb opened the driver's door roughly. Get out. Nah. Carter stepped out slowly, her hands visible. I'm complying. There's no need for force. I'm not resisting. Webb grabbed her arm, harder than necessary, and spun her toward the car. Hands on the vehicle. Officer Webb, she read his nameplate. You are detaining a federal judge on the side of a public interstate without reasonable suspicion or probable cause. Your body cam is recording this. Your dash cam is recording this. And that witness, she gestured with her head toward the pickup truck, is recording this. You need to verify my credentials before this goes any further. I don't need to verify anything. You were driving erratically. You failed to comply with a lawful order, and now you're going to be cited for obstruction. Webb pulled Carter's arms behind her back. For a moment, it seemed like he was going to handcuff her. Then his radio crackled. A voice from dispatch. All units be advised, we've received a call from the federal courthouse. Caller states Judge Evelyn Carter is en route to a 9 o'clock hearing, and may have been pulled over on eastbound to 185. Requesting confirmation of status. Webb froze. His hand was still on Carter's wrist. His body cam was still recording. The witness was still filming. Carter's voice remained calm, but the edge was unmistakable. Officer Webb, that call is about me. I am Judge Evelyn Carter. I've been trying to tell you that for the past 5 minutes. Now I suggest you verify my identity before you compound this violation. Webb released her wrist and stepped back. He looked at her driver's license again. He looked at her face. He looked at the expensive car, the briefcase visible through the window, the judicial robes hanging in the back seat. For the first time, doubt crept into his expression. Stay here. Don't move. He walked back to his patrol car and picked up his radio. The witness in the pickup truck was still recording. Traffic was still rushing past. And Judge Carter stood on the shoulder of Interstate 185, her professional reputation intact, but her morning commute transformed into a federal civil rights violation. Should officers be required to verify professional credentials before detaining judges, attorneys, or federal agents? Let me know what you think. Webb spent 3 minutes in his patrol car, on the radio with dispatch and his supervisor. The conversation was tense, clipped, increasingly desperate on Webb's end. Within 6 minutes, a second patrol car arrived. Sergeant Linda Hayes, a 23-year veteran who had supervised traffic units for 11 years, and had personally reviewed several of Webb's prior complaints. Hayes pulled up behind Webb's car, got out, and walked directly to Judge Carter, who was still standing beside her vehicle. Mom, I'm Sergeant Hayes. I apologize for the delay. Can you provide identification? Carter handed over her driver's license and, from her briefcase, her judicial credentials. The leather case containing her federal judicial ed, complete with her photo, the seal of the United States District Court, and her official title. Hayes examined them carefully. Then she looked up at Carter with an expression of mixed embarrassment and anger. Judge Carter, on behalf of the DeKalb County Police Department, I sincerely apologize. This stop should never have happened. Hayes walked to where Webb was standing by his patrol car, his face pale, his confidence evaporated. Her voice was low but audible to the witness still recording from the pickup truck. Webb, what the hell were you thinking? She was swerving. I had reasonable suspicion. Your dash cam will show whether she was swerving or not. And unless that footage shows a clear violation, you just detained a federal judge without cause. I didn't know she was a judge. She told you she was a judge. Multiple times. She offered to show you her credentials. You refused to verify. She looked at the witness recording, then back at Webb. And now it's all on video. Hayes walked back to Judge Carter. Mum, you're free to go. No citation will be issued. Again, I apologize. Carter's voice was measured but firm. Sergeant Hayes, I appreciate your professionalism. However, this stop was unlawful from the beginning. Officer Webb manufactured a violation, refused to verify my credentials, and detained me without reasonable suspicion. I'll be filing a formal complaint, and I'll be consulting with attorneys regarding a civil rights lawsuit. Hayes nodded. That's your right, Mum, and frankly, I don't blame you. Carter got into her car, started the engine, and drove away. She was 20 minutes late for her hearing. Her hands were shaking slightly, not from fear, but from anger. She had presided over cases involving exactly this kind of misconduct. Now she was the victim. Webb stood on the shoulder, watching her drive away, finally understanding what he had done. Hayes turned to him, her voice cold. Back to the station. Nah, you're on administrative duty pending investigation. Sergeant, you detained a federal judge, Webb. A federal judge with a national reputation, a perfect driving record, and absolutely no reason to be pulled over except that you saw a black woman in a nice car and decided she didn't belong. Give me your ticket book. You're off traffic duty. The man in the pickup truck approached Hayes. Excuse me, Sergeant. I recorded the entire stop. If the judge needs it for her complaint, I'm happy to provide it. Hayes took his contact information. She knew the recording would surface. She knew this was going to become a problem for the department. Webb got into his patrol car and drove back to the station, his career effectively over. Should officers who detain judges or federal officials without cause face immediate suspension? Drop your answer. Within 48 hours, the story had spread across legal circles, then mainstream media, then social media. The witness's video showed everything. Judge Carter calmly identifying herself, offering credentials, being forced from her vehicle, standing on the shoulder, while Webb ignored her repeated explanations. The dashcam and bodycam footage, released after a public records request, confirmed what the witness video showed. No traffic violation, no erratic driving, no reasonable suspicion. Just a black woman driving to work, pulled over for existing. Federal judge detained by officer who refused to believe her credentials were real. Cop pulls over federal judge, accuses her of lying about her identity. DeKalb officer on leave after unlawful stop of a district court judge. The outrage was immediate and intense. The federal judiciary issued a rare public statement expressing concern about the incident and supporting Judge Carter. The Atlanta Bar Association condemned the stop. Civil rights organizations called for Webb's termination and a federal investigation into the DeKalb County Police Department's pattern of racially motivated traffic stops. Webb was placed on administrative leave within 24 hours. The department launched an internal affairs investigation. The district attorney's office began reviewing whether criminal charges for false imprisonment were warranted. Webb's union initially issued a statement defending him, claiming he had acted in good faith based on his observations. That position lasted approximately 72 hours before the dashcam footage was released publicly, showing Carter driving perfectly legally in the right lane while Webb paced her looking for a violation that didn't exist. Webb released no public statement. He hired a criminal defense attorney and a labor attorney. He went silent. Judge Carter contacted civil rights attorneys within a week. She didn't want money. She wanted accountability. She wanted the system that had protected Webb for 11 years to face consequences. The lawsuit, filed in the very courthouse where Judge Carter presided, named Officer Marcus Webb individually Sergeant Linda Hayes for supervisory failure, and DeKalb County. The case was assigned to another federal judge to avoid any appearance of impropriety. The claims were comprehensive and damning. Unlawful seizure in violation of the Fourth Amendment. Deprivation of civil rights under federal law. Racial profiling in violation of the Equal Protection Clause of the 14th Amendment. False imprisonment under Georgia state law. Intentional infliction of emotional distress. Failure to train and supervise officers with documented patterns of constitutional violations. Municipal liability for maintaining policies that enabled discriminatory policing. The complaint included Webb's complete disciplinary record. 14 complaints over 11 years, 10 involving allegations of racial profiling, for sustained complaints, and 0 meaningful consequences that changed his behavior. The pattern was documented across 44 pages of exhibits, witness statements, and prior complaints that the department had dismissed or minimized. DeKalb County's attorneys reviewed the evidence. The dash cam, the body cam, the witness video, Webb's disciplinary history, the fact that a federal judge with impeccable credibility was the plaintiff, and reached an immediate conclusion. Indefensible. The county settled within 8 months, paying $4.7 million to Judge Evelyn Carter. The settlement included comprehensive policy reforms, mandatory credential verification for any professional who identifies themselves during a traffic stop, immediate suspension for any officer with 5 sustained complaints involving racial profiling, body cameras that officers cannot turn off or mute during traffic stops, quarterly pattern analysis of all traffic stops flagged by race and vehicle type, independent civilian review board with subpoena power and binding disciplinary authority, federal monitoring for 5 years. Officer Marcus Webb was terminated 11 weeks after the incident. The termination letter was final. Officer Webb conducted an unlawful traffic stop without reasonable suspicion, refused to verify the credentials of a federal judge despite repeated requests, and engaged in racial profiling. Officer Webb's 11-year record includes 14 complaints, 10 involving racial profiling, and 4 sustained findings. Despite repeated training and disciplinary actions, Officer Webb continued to engage in discriminatory policing that violated department policy, constitutional rights, and community trust. His employment is terminated effective immediately. This termination is final and not subject to appeal. Webb's name was entered into the National Decertification Index. His law enforcement career was over at 38 years old. He would never work as a police officer again. Should counties face financial penalties in addition to paying settlements when officers with documented patterns of misconduct violate civil rights? Let me know in the comments. Judge Evelyn Carter testified before the DeKalb County Board of Commissioners 9 months after the incident. The hearing room was packed with community members, attorneys, activists, and media. Her testimony was measured, precise, and devastating. I've served on the federal bench for 19 years. She paused, letting the weight of that experience settle over the room. I've presided over dozens of cases involving police misconduct, unlawful stops, and civil rights violations. I've read thousands of pages of testimony from officers who claimed they had reasonable suspicion when they didn't. I've reviewed countless dashcam videos showing traffic stops that never should have happened. Another pause. And on September 23rd of this year, I became one of those cases. Her voice remained calm but carried an edge that made every person in the room lean forward. I was driving to work. I was in the right lane. I was traveling 62 miles per hour in a 65 zone. I signaled every movement. I committed no traffic violation. And Officer Webb pulled me over anyway. She looked directly at the commissioners. When I identified myself as a federal judge, he didn't believe me. When I offered to show him my credentials, he refused. When I asked for the legal basis for the stop, he ordered me out of my vehicle. When I complied, he grabbed my arm and prepared to detain me on the side of an interstate. Not because I had violated any law, but because I'm a black woman, and he didn't think I belonged in that car. The room was absolutely silent. Officer Webb had 14 complaints in 11 years. 14. 10 involving racial profiling. 4 sustained. And somehow, he was still on patrol, still making stops, still targeting black drivers in expensive cars. Her voice strengthened. This county paid $4.7 million to settle my lawsuit. That's accountability. Officer Webb was terminated. That's consequence. But money doesn't undo the violation. Termination doesn't change the fact that this department knew, for 11 years, that Webb was targeting black drivers, and they did nothing meaningful to stop him. One more pause, longer this time. If this can happen to a federal judge, someone with credentials, authority, and resources, what happens to everyone else? What happens to the black teenager driving his mother's car? What happens to the black woman coming home from her shift? What happens to people who don't have the power to fight back? She let the question hang in the air. That's what this case is really about. Not just one unlawful stop, but a system that protects officers who engage in racial profiling until they target someone who can't be ignored. The hearing room remained silent for several seconds after she finished. Then someone in the back started clapping. Others joined. The commissioners looked uncomfortable, but they couldn't deny what they had just heard. Should racial profiling during traffic stops trigger automatic federal civil rights investigations? Drop your answer. This wasn't just about one traffic stop on one Thursday morning. This was about a system that kept Marcus Webb on patrol for 11 years despite 14 complaints. This was about a department that treated each complaint in isolation, never connecting them into the pattern they clearly formed. This was about the thousands of black drivers who have been pulled over by officers like Webb and didn't have the resources, credentials, or platform to fight back. Webb's record told the story his supervisors ignored. 14 complaints over 11 years, 10 involving people of color, 4 sustained, resulting in written reprimands, suspensions, and mandatory training. But training without accountability is just paperwork. The pattern was undeniable. Webb saw black people in spaces where he didn't think they belonged, expensive cars, affluent neighborhoods, professional contexts, and he used his authority to challenge their right to be there. Every complaint was treated as an isolated incident. Every sustained finding resulted in retraining that never changed behavior. Every suspension ended with Webb returning to the same patrol route, making the same kinds of stops, targeting the same kinds of drivers. The system was designed to protect the officer, not the community. Marcus Webb's career is over. That's consequence. DeKalb County paid for $0.7 million. That's accountability. The department faces federal monitoring and mandatory reforms. That's oversight. But money doesn't undo the violation of being detained on the side of an interstate for the crime of driving while black. Termination doesn't restore the dignity of having your credentials dismissed as lies. Reforms don't erase the reality that even a federal judgeship wasn't enough to protect Judge Carter from racial profiling. The real question is, what changes now? Do police departments finally remove officers after 5 sustained complaints instead of 14? Do they finally analyze patterns instead of treating each complaint as isolated? Do supervisors finally take action when the evidence is clear? Do we finally acknowledge that reasonable suspicion can't mean black person in NASCAR? Do we finally recognize that traffic stops are where constitutional rights go to die for people of color? Because if we don't fix the system that kept Webb on patrol for 11 years despite 14 complaints, if we don't address the culture that taught him black drivers are inherently suspicious, then we're just waiting for the next officer, the next stop, the next victim, the next lawsuit. Judge Carter got justice because she had power. But justice shouldn't require power. It should be universal. Comment if you believe this should be law. Officers with 5 sustained complaints for racial profiling or constitutional violations face automatic termination and decertification nationwide. And if you think these stories need to be told, if you believe accountability starts with exposure and change starts with pressure, then hit that subscribe button. We're not stopping. We're going to keep exposing these patterns. We're going to keep demanding that police departments treat 5 complaints as a pattern, not as isolated mistakes. We're going to keep fighting for the federal judges, the everyday drivers, the teenagers, and everyone who deserves to drive to work without being profiled. This isn't just about one officer or one judge. It's about all of us and the America we're willing to accept. One where your credentials don't matter if your skin is the wrong color, or one where constitutional rights apply equally regardless of who's behind the wheel.